Namaste, viewers, and a warm welcome to yet another episode of the Indian Lawyer Legal Tips. Warm regards from Team the Indian Lawyer, and we genuinely hope that each episode is of help to the people who are watching it. I am Sushila Varma, Chief Consultant with the firm. Today's topic is going to be about ancestral property, what it means, and the sale of such properties, when and how it can be done. Now let us begin with what is ancestral property. Ancestral property refers to a property inherited up to 4 generations of male lineage in a Hindu undivided family. This means the father's father's father. Hence, all coparceners, including sons and daughters, post 2005, when there has been an amendment regarding the daughter's rights, have an equal and automatic right to ancestral property by birth. Before we go any further, let us understand what are the essential requirements of ancestral property. The first would be automatic interest that devolves upon a person, male or female, by birth. That is, the minute a person is born into a joint Hindu family, he or she acquires an interest in the said property. The second important aspect would be the undivided status, that is, the property that belongs to the HUF must remain joint and undivided until and unless a formal partition is done. The law that governs this particular system of HUF, which gives both male and female descendants an equal right, is the Hindu Succession Act, and the law that allows the daughters to have an equal right in the property is the Hindu Succession Amendment Act 2005. Now, what is the role of the Karta and what are the rights of the coparceners? The Karta is usually the eldest male member in the family who manages the joint property. However, the Karta's duties and powers are limited and subject to his fiduciary responsibilities towards all members. Now, let us examine what are the rights of the coparceners. The first would be that any coparcener can seek division of the property to claim their share. The second, transactions adversely affecting their rights or interests can be challenged by the coparceners. And the third would be that the coparceners have the right to prevent misuse or unauthorized sale of property by the Karta. Now, let us examine what is the power of the Karta. The Karta has a very limited authority to alienate or sell or even lease ancestral property. He can do it only with the consent of all the coparceners. However, if there is some necessity in the family, like a medical emergency or a wedding, Karta can use his wisdom and decide to sell or alienate a particular property. The Karta can also use his wisdom when it comes to taking actions that will preserve or enhance the property's values. Now coming to the most vital question, can ancestral property be sold? The answer is, in general, ancestral property cannot be sold or disposed of without the consent of all the legal successors or the coparceners unless there is a legal provision or necessity for such a transaction. Under the Hindu Succession Act, ancestral property is jointly owned by all coparceners by birth. Therefore, any sale, donation, or disposition of the property typically requires the consent of all coparceners. Although a person may dispose of the self-acquired property through a will, ancestral property generally cannot be willed away to a single person. Now let us understand what is the meaning of legal necessity when we're talking about ancestral property. This was discussed by the Supreme Court of India in a case Balwant Singh versus Daulat Singh 1997, where the Supreme Court emphasized the importance of legal necessity, ruling that sales that were made during this period when there was a legal necessity is voidable only at the option of the coparceners. However, it upheld if a sale was made keeping in mind legal necessity, it should not be challenged. In another case, Kehar Singh versus Nachitar Kaur, 2018, the Supreme Court held that the family Karta has the right to sell ancestral property if there is a necessity and laid down certain conditions when such a legal necessity for which a sale could be done by the Karta was laid down. The first would be government debts and taxes, then family maintenance, marriage expenses, funeral expenses, litigation expenses, defense against serious allegations to the joint Hindu family, and business debts. In a judgment called Satish Kumar versus R. Rajalingam 2020-21, the Supreme Court emphasized the Karta's fiduciary duty and the necessity of getting consent. The Supreme Court held that while the Karta was the fiduciary head and had the right or the duty to protect the family members, however, the family members also had a right to challenge any decision if they felt it was not correct. In yet another judgment in 2022, K.C. Lakshmana versus K.C. Chandrappa Gowda, the Supreme Court ruled that the managing member of HUF can gift ancestral property for a pious purpose, and such a donation will not be challenged. However, challenging of unauthorized sales is something that can be done by coparceners, and in order to do so, they can either file a suit to nullify the transaction, seek damages for financial loss again in a suit filed in court, or they can prevent execution of the sale by getting an injunction from a court of law. Now let us examine another aspect of coparcenery property. This would be the expansion of coparcenery rights to daughters. The Hindu Succession Amendment Act 2005 was a landmark legislation that expanded the coparcenery rights under Hindu law to women. Earlier, it was a male-centric framework when it came to inheritance for HUF properties. However, now, after the amendment of 2005, daughters are granted equal rights to HUF properties like the son, and they also have the same right to inherit and manage the family property. This amendment applied to both living daughters and those born after the enactment, though the rights of daughters before the amendment remained subject to legal interpretation. In 2013, in a judgment called Rohit Chauhan versus Surinder Singh, the Supreme Court affirmed the daughter's consent is required for sale of any ancestral property. In yet another judgment, that is Vinita Sharma versus Rakesh Sharma, passed in 2020, the Supreme Court again reaffirmed the daughters as co-partners by birth and held that a daughter's consent was required when selling a HUF property. Now let us examine another very important and a very interesting aspect of ancestral property. Do children born out of live-in relationships have a right on ancestral property? The Supreme Court of India in 2022 passed a judgment, Katukandi Idatil Krishnan versus Valsan, in which the Supreme Court of India held that children born out of a live-in relationship are entitled to inherit ancestral property as co-partners. This judgment established that if parents have cohabited in a live-in relationship, but for a significant period, the child born from such a unison is considered to have a right, a legitimate right under the Hindu law on the property of the father, even when the property is ancestral property. The court referred to the progression and interpretation of Hindu law principles and aligned its rulings with Article 14 of the Indian Constitution, which guarantees equality. The court in this judgment recognized the evolving social fabric and ensured that children from live-in relationships are not deprived of the inheritance solely because their parents did not get married. Now, in conclusion, let me conclude by saying Sale of ancestral property without the consent of the coparceners or the successors is a legally complex topic, and it depends from case to case. As already explained earlier, if the Karta can show legal necessity, the sale would probably be upheld. But in the event that he cannot show legal necessity, the sale can be set aside. Dear viewers, thank you for consistently watching our episodes, and thank you for subscribing. We are happy to say that our base is growing from strength to strength. We hope that these particular episodes of Legal Tips reach the right people, and we request you to kindly circulate these episodes so that we can have a better outreach and more people can understand how the law can protect them. Thank you.